Okay, welcome everyone. This is February 13th, the day before Valentine's Day, 2019. Welcome to Brilliance in Commerce and the Trust Webinar 13, February 13th. We are going into a very interesting period in history, as you know, a time in the transition between the Dark Age and the Golden Age. And the traditional concepts of generations ago that have been serving the good, the healthy, the happy, the bright, the light, are surviving and flourishing and expanding. So welcome, thank you for joining us. We'll get right into going ahead with today's topics. We are Brilliance in Commerce, a project of La Vérité, which means the truth in French, House of Freedom International Natural Law Trusts, Liberty Debt Elimination System. We have affiliations, meaning anyone can join us to help spread the word. We have wealth building systems, credit repair, gold purchasing concierge, offshore asset protection, Monaco Management Group, wealth management, cryptocurrencies, and so forth. We are signatories to the Worldwide Charter for Fair International Commerce, and that is a project of the United Nations Organization, International Business Standards Organization. Today, we are going to be proceeding as we do every month with our wonderful, illustrious speaker, Randall Hillner. And next month, March, again, 28 days from now, the 13th, we will continue with the series. So today, February 13th, next webinar, March 13th. You can put it on your calendar. House of Freedom Natural Law Trust has the website house-of-freedom-trust.com for those of you who did not already have an affiliate URL or our website address. That leads directly to the trust page. And our phone number for those who need it, 360-200-7521. For those outside the United States, dial the United States 01 prefix and then 360-200-7521. My name is Tonson Fairmont. I'm the founder, member of the Board of Advisors of Monaco Management Group. I've been a speaker on radio shows and offshore investment seminars and the author of Sovereignty Consciousness and the forthcoming Cosmic Renaissance. We call our trust international because they are not subject to the jurisdiction of any government or any locality or geography for the sake of validity or authorization. They do not derive their authority to exist from a statutory body. They derive their authority to exist under the universal right of contract, which is worldwide, it's global. We call it natural law to distinguish it from the many inferior common law trusts, although in practice, the transactions of the trust can be based on the common law of any particular area of the world. It's been a best kept secret of the super rich. It's been known that the wealthiest families in the world have them. The Vatican, the Federal Reserve, many of the elite have used this design. They have traditionally been called many things: Massachusetts trusts, Kennedy's, Mellons, Hunt Brothers, many other families have used them. Today is a day when you hold in the palm of your hand a smartphone which has more computing power than 50 years ago the biggest computers have, same as trust technology. It has been advancing, it's been growing, and the great technology of asset protection at its most advanced level has been inherited, has become into the hands of average people like us. And thanks to Randall, we've been able to derive the greatest teachings of the best mentors. And that's what we're going to focus on today, is what are the teachings of the mentors, the people who understand the best principles of trust law. Randall is the head of our Brilliance in Commerce Trust Department. He's the founder of House of Freedom Trust, White Light Unlimited, One People's Public Trust, and the creator of the International Natural Law Trust. Today we're going to be going into what the elite asset protection mentors have been teaching, the most adept masters. These are the ones that Randall has studied with, and I've read some of their works, and so some of you have. These are the people who are not necessarily attorneys. Attorneys, bless their hearts, have been to law schools where most of the laws are geared towards the vested interests. They are statutory. Generally, the trusts that come under statutory law are expensive, complicated, unnecessarily wordy, full of legalese, require professionals to interpret, to write, and they are considered not favored by the more advanced families for the simple reason that private contract law is superior and transcends the provincial statutory law that changes every year, that changes every time Congress is in session or Parliament is in session. The common laws, the natural laws of don't steal, don't lie, don't cheat, don't violate the rights of others, keep your word, keep your contracts, your agreements. These basic principles underlie the Uniform Commercial Code, which is global. And in harmony with that, the Natural Law Trust operates based on principles that have been elaborated on by mentors for many generations. So, without further ado, I'm going to bring on Randall and invite you, Randall, please, to go ahead and turn your video on and join us and proceed with our first lesson of the day.
Okay, I don't see my microphone. Should be on. Can you hear me?
Yes, yes, yes. Your video is on. Your sound is loud and clear.
Great. Well,
looking good.
Thank you. Thank you.
Aloha.
Do you have more to say? Do you have more to say?
No, go ahead. Aloha.
Okay. All right. Hey, folks. Welcome to House of Freedom Works. And some of you in the audience have had our trust, and some of you are in that loop where they got to make some decisions, and so that they can step into our private irrevocable trust and your contract with trustees, either yourself or anybody else. And looks all good to me. Let me pull in my Zoom. Okay, don't see why I'm not on the screen. That is really strange.
Can you see the slide?
No, there's no slide.
Yeah, we're doing the screen sharing and the slide is up, definition of terms, and your video is in the thumbnail.
Well,
we're getting comments in the chat saying they can see you very well.
I can't see. I thought I unmuted my sound. Do you hear me, Thompson?
Yes. Do you hear me?
Yes, absolutely. I just don't see any slides. So
well, everybody's seeing and hearing you. How to see your slides? How did you do it before last month?
Oh, I can't remember yesterday. Never mind. I don't know. Let me search. And I apologize for taking so much time. I had to Zoom and I waited and
Well, until you find it, I can read the text to you. Definition of terms, classification of trusts.
I have those notes here. So why don't I just you Zoom into me and I'll read some of my notes that I've made and we'll go from there. How's that?
Okay.
Okay. So hello, everybody. I hope we can do this. This is a different process because I don't have any slides in front of me, but I do have, oh, here we are. Hey, thank you, Townsend. Very good.
I didn't do anything.
Well, must be my fault then. Okay, we got these beautiful definition of terms. And that green all over there looks like my front yard. It's pure jungle. You have to make a path through it every couple of days just to get to the car. That's how steep we are in greenery. So today we're going to talk about the whole essence of what we do together. Some of you are settlers or grantors. Some of you are working in the trustee role. So we're going to talk about those different things and what each one means. So on number one, we have active versus passive. Okay, so that's classification of our trust, and how that works is if, in fact, the trustees are doing the investing with the asset. Suppose you give something into the trust, and the trustees are going to take it and run with it. You're going to, as grantor, let's say you say to the trustees, okay, I would like so much to go here and so much to go there. And then that's called an active trust because the trustees are taking part, and you as general manager, if you're the grantor, let's say you're the grantor and you have two trustees, let's get on that particular cycle. So you may make a list of things that you want to do, and you want the trustees to make it all happen. So they work with you and invest here, invest there. They actually are, you're like your wealth manager. You have assets that have gone into the trust, and between you being a general manager or anything else, then you are having the trustees take an active position, which creates an active trust. So in other words, it's a working document, and it's always upgrading and refining, doing the investing in different commodities or whatever you want to do. So this is a role that most of you are going to be involved with because the trust is meant to be kind of active. But I have a few clients that have had an asset and they don't want to work it at all. It's all set. There's certain amounts of money that come to the trust. And so that would be like a passive trust. The trustees really don't do a lot of work because you have given your asset to the trust and it's going to sit there. Sometimes people have a portfolio. They turn the whole portfolio to the trustees of the trust, and then it just sits there and churns. And the trustees, or you and the trustees, say, okay, we're going to send a check every month to you, and that's how the trust works. On the other side is where the trustees are actively working to invest that asset portfolio into different commodities, whatever you think is right for your working terms and whatever you'd like to do. So active and passive is a minor role, but it actually plays out really well. let's say now you have minimal portfolio, minimal assets, but you're expecting something big to come along into your den of having a good life. And so it would be an active role, active and passive. The passive one would be where the trustees just take that portfolio and stick it into an asset building process, and then there's no real work involved. Whereas with an active trust, you as manager or the trustees as trustees have to get involved on a daily or weekly basis anyway and work it. If you're the general manager, say you're the grantor and you just want to be the general manager and you want two people to be trustees, as long as one of the trustees is unrelated to you, then that would work. So we have two trustees. Now you can have a situation where you want the trustees will be co-trustees. And so what that means is that one of the trustees can be a family member related to you. The other trustee has to be unrelated to you or the beneficiaries. So that's the working model of active versus passive. It can change over time. You'll have, when you work your way through the trust document, begin to understand it really well, you'll see that there are a lot of things that you can do, and it can go there. It can go anywhere it wants. And like Tanzan said, because it's a right to contract anywhere in the world, you could use a U.S. address or use whatever address you want, and then you put it in action. Some places like in the U.S., you need to the trust needs to file for a EIN number so that you can take it and put it in a trust document. And then when you go to the bank is going to want to see that contract. So you have two trustees, either a co-trustee or you might be a sole trustee. Let's say you're not one of the beneficiaries. You play the managerial role, and then you take care of this trust for the beneficiaries in the trust. You might had a recent client that wanted to basically, she was going to get a nominee trustee, which we can provide. Also, I would prefer that you had your own grantor. And then either, let's say you would be one of the trustees, and you would have a co-trustee, or you'd have a successor trustee. And the reason you need to have more than one trustee is because one is the banks won't give you an account because they want to see that if something happens to you, there's another trustee. This is basically because you have decided that you want one trustee and you have the other trustee be a successor trustee. So as long as you have them listed and they can step into that role, then it's okay. So there's active versus passive. Mostly what we work with in House of Freedom Trust is the active-oriented trust, where you and the trustee is going to take the active role in the process of the trust. So that's active and passive. That's fairly simple. I think you most would understand that. And then we have, is it private or charitable? You can, even if it's not a charitable trust, you can, by law, take some of that assets out from the trust and give it to any charity you'd like. But in a sense, you're establishing a private irrevocable trust. Private irrevocable trust. And that means that it's not under the sanctions of any government, and you can go, if you live out of the country and you want a U.S. tax number, you can get a foreign tax number. And that allows you to work, let's say you're not in the US, then you can work that trust wherever you want to be. Now that's how that goes, a private irrevocable trust. And then is it express or constructive? Okay, an express trust, you have decided that you are going to create a trust. You have an asset that you want to put in, and that would be an express trust. That's lost my thought there for a minute, but express or constructive. A constructive trust would be, let's say you have an asset and you're passing on, and so in your will you say, I want this particular asset to go into a constructive trust. So in other words, somebody else will set it up, and then it goes from there. You have your beneficiaries in mind, you have the trustees in mind, and so there you go, active and passive, private or charitable, and express or constructive. Again, let's stay on the left-hand lane and say that's an active, private, express trust, houseoffreedomtrust.com. So that's, if you keep your questions, just write them down and keep it aside. We'll, as soon as this little process is happening, then we're going to open it up to questions. And I love doing questions because it's a more active participation for me. Here I am just talking my skill language, and hopefully I get it simple enough so that it can be understood by everybody and anybody. Okay, next slide. Okay, expression of intent. Okay, so this is where you have saying, I want to create a trust, and you come to us and we step in and we create this dynamic trust for you. And it's then it has to be written. So the form of expression is that you have to have a document in front of you, a trust document or a contract, if you want to call it that. It's really one way or both ways, whatever you want to do. And then the intent is you can't, you have to take what it is that you would like to have the trustees do, or as trustee, what you want to do. And the intent has to be clear cut, and it must have an asset to go into it. Now, some of you are not really putting anything into it. You're stretching the dollar to go and either pay for on a monthly payment or to buy up the trust right away. And that, as long as the intent is legal and there's not going to be any illegal process involved, then your intent's clear. And then the next one about time expressed is you need, especially around foreign currency and the RV, you have to date stamp your assigning the assets into the trust so that you don't own it anymore and the trust does. But that's a time expressed or a date stamp expressed. In other words, when I send you the form or we get the form, I may come email back to you and say, okay, or a client will call me and say, what do I put for a date? Because I paid for it 5 months ago and haven't done anything with it. What am I going to do? Well, you can use for the date created, this is when you go to get the IRS EIN number, you have to have a creation date. We're going to ask for that. So you can use present time, or you can go back to when you first either heard me and Tanzan, or you knew that you wanted to do that, and that would be that date. So you might be, let's see, we're going into March, but let's say you want to date it to the first of the year. You just have to use that as your creation date, and you would use present day for the indenture. In other words, you might tell, when you go to get the number, you might say that this is created on the 1st of January. But when you sign it, you can use current time, current date, and that is your solid time expressed. So you have a form of expression, which is the trust document. It's very clear when you get the document. Those of you who have it have seen it, and I encourage all of you, because I've fielded many questions. Well, what date do I use, and what am I going to need? And that document can then be considered work in progress, and the date is either first of the year or whenever you first thought about it, and then you have to sign some of the documents in current time. And if you're doing this for the RV and just waiting for the RV to happen, then it doesn't matter, but you have stamped your date on there and sign it under that date. So it's very flexible, but you do Tanzan, is that directed to me, or are you just fielding questions? Anyway, I'll just go on from there. So we have form of expression, which is a word form. You're expressing that you want to have a trust. You have a purposeful intent, as long as it's not illegal. And then you have the date that you want to use as a creation date. You can use today's date if you want to say expressed and the time expressed. Or you can go back in time to when you first thought about it. It's really not going to matter, except you have to put some creation date when you file for an EIN number. And the EIN number basically is for opening up a bank account. In the US in particular, the bank won't open an account unless you have an EIN number for the trust. You can't use your Social Security number, and you can't use a number from another entity. You must have its own entity, an EIN number for your particular entity. So that's form, intent, and date or time of expression. Okay, next. Okay, so now we have trust property. So you've had, basically, you need an asset to begin the trust. And when you pay money to the House of Freedom for the trust document, you have activated this trust, and just the fact that you're paying for the trust allows that process to happen effortlessly. So the trust property is the res that you're going to put in. Now we can start there, because let's say you have paid full price for this trust. That is part of funding the trust. Then you have the ability to take other assets and put them in trust and have the trustees work it, or yourself on a day-to-day basis, being able to take care of business, ordinary business, and trustees only have to step in on a major decision. Although even as executive manager, whenever you do an action, it's important to write it yourself as a minute, and then make sure your trustees also know what you've done, what assets you've put in the trust, and what kind of interest you have in the property. Now, let's say you have, let's say gold, for instance. So interest in property means you have bought some gold or silver or land, and you have to have the trustees Like the trustees would be the ones to go to the county office to register a new deed. A lot of banks require that both trustees are there. Some do, some don't. It depends on their own flexibility. And I've had success both ways. I've had to walk out of the trust or the bank and go find another bank, which has been quite successful. Typically, after most of the time, I go in and it's open because I'm either the trustee or I take Marissa, my partner, and we go together and we both sign on the card. If you go by yourself and the bank says who's, you say I have a successor trustee and you have their name and you have their signature on a document that we provide with the whole trust document indenture, then the bank will say, okay, as long as you have an interest in whatever property you're putting in there, that's hard asset or land or something. Let's say just in the RV, there's a section in the trust where you have to get, that's the only page that has to be notarized, is the fact that you have taken it from your pocket and assigned it to the trust. And that has to be date stamped by a notary. In some places in Europe, you have to go and get it notarized through an attorney, but he's just authorizing, or whoever's date stamping your trust. You have to have that. It's only one section that you need to have notarized, or you can do all three of them. There's the manager's agreement, and there's a trust certification, and then the minutes need to be signed, and then foreign currency would have to be, it's really important that that is date stamped. That means that you don't own it after that date, and that then you just wait for the RV to happen and move on from there. So there'll be a lot of effort to set it up, to really understand. Ask all of you when you get the trust document and you get the manual that you really read it until you get a grip and you really understand what this all means, because it affects not only you in present time, but it protects your beneficiaries into the future. Now, that's what you want. You don't want to have to go, your estate to go through, what is it, when you die, they, anyway, they give you, you have to go get it assayed, etc.
Probate.
Now, alienability is you have to be able to have that property or that asset, res, it's called a res, it's trust property, and here you go from there. You can add to it, you might subtract from it, but if you set it up right and you have proper wealth managers, or you know how to manage it yourself, either trading on your own or trading through a brokerage account, that alienability means that you have a right to do with the trust as you would like to. Again, in that scene, it's really important that the trustees know about this, and they may have to do some signing also when it goes into the trust. The trustees need to accept this res or property that you're putting into trust, either a hard asset or a soft asset, or real estate. So you have personal property, you might have some gemstones or jewelry that you want to have owned by the trust so that it doesn't go anywhere when you pass on, which is probate. So the thing about an irrevocable private trust is you will never have to deal with probate, and neither will any of your beneficiaries. So that's the ability to put that property into the trust, have it date stamped or notarized, and then go from there. And it has to be identifiable, so the must be stated. So that's why we have. We have two parts to the trust. Well, there's more. There's like 5 parts, but you have the trust indenture, Then you have your trustees accepting and signing their willingness to be a trustee, and you have to make sure that they know what's going into the trust, whether it's hard asset, gold, silver, jewelry, or maybe some paintings that you have that you want to make sure don't go anywhere. And so that's the ability to alienate and the ability you have identified what goes into the trust. So every time you want to add to the trust res or property, you would present this to the trustees and say, okay, I want to put this property into the trust. Then the trust owns it and you don't. And you can, ideally you would want to make sure that you have a list of those things in trust. So we have a bunch of schedules that I'm going to talk about a little bit later, but that's basically it. You have an interest in the property. You have the right to alienate and move that property away from you. And then identifiable means that it tells exactly what it is. 10 pieces of silver, 10 ounces of silver, a couple of ounces of gold, and also getting ready for the RV and the being able to use the foreign currency that you have had in your hands for a period of time now goes into the trust. Okay, next. Okay, we've covered this before, but I want to make sure that you know how to work this. So when you as a interested party comes and either emails me or calls me or wants to talk about it, then I help them decide, or you decide, whether you want to be the grantor, settlor, do you want to be one of the trustees and get another trustee, and then the beneficiaries, who are they? So you have to have at least two of those happening. You can get a nominee grantor, which we would supply if you get a hold of me and Tunson. Trustees are up to you. You can be one of the trustees as long as you have a second trustee that's not related to you or the beneficiaries. Now, in this case, if you're one of the trustees, you could be the sole trustee as long as you have a document that says, in the case of my demise, then this person is going to take over handling the trust and the duties of a trustee. It's always nice to have two trustees. You work as a co-trustee. You can have a successor trustee from there also. Had clients that want to be one of the trustees, so we provide a nominee grantor, and we have then you're left with finding one person that you feel is trustworthy and will work with you to be that second non-related trustee. It's quite simple when you think about it. Then the beneficiaries. Had a client this morning that I started to write for, and he had a list of beneficiaries, and one of the beneficiaries can be you as long as you have a co-trustee that's not related to you, and you also have more than yourself as the beneficiary. You can be the grantor and a beneficiary all by yourself as long as you have some trustees, two people that will work as trustees for you, either co-trustees or successor trustee, who would take over on the demise of the other trustee. And then the beneficiaries are whoever you want, and you can have one or many. Okay, next slide. Okay, trust purpose. Obviously, the purpose, well, purpose in general is that you want to create a trust and you want to put assets in it to be protected from suit and or probate. But the purpose of setting up the trust must be lawful. In other words, you can't run an illegal business out of a trust and and make it work, because at some point that will put all of the trust asset in jeopardy. So you want to have anything lawful. If you're doing unlawful stuff, then keep it in your side pocket and don't put it in with a trust that will taint whatever assets you may have in there as well. And the permissible duration is a rule against perpetuities. Means you can't just say forever. You have to have an ending date at some point, maybe. So the rule against perpetuities means that I have it written in our trust for House of Freedom that it's 21 years plus lives in being. So in other words, let's say you have children and you have grandchildren, then the trust would be able to stay renewed because there's people out there who are going to grow into it after the 21 years. And you start with 21 years, and then at the end of the 21 years, you have to decide, you and the trustees have to decide whether you're going to end it or whether you're going to carry on. In other words, some people just say, okay, I want it so that when I pass on, that whatever's in the trust goes to the beneficiaries. And so right there, you have stated that, okay, at the end of 21 years after your demise and the demise of those people that are alive at the time that you created the trust, then it can go on or it can be shut down. In other words, the trustees or the beneficiaries may say, my grandfather who created this trust has passed on, and I would like to take my share and do something else with it. And that's okay. You can do that. And a rule against accumulation is that the trust can't accumulate beyond the time frame that happens when you create the trust. So we have perpetuities is that at some point you're going to pass, and whoever was alive at the time that you created it, after they are done, they can either say your grandchildren are some of the beneficiaries. Then they can say to the trustees, we would like to have the trust end and take our share now. And then accumulation is so that the trust set up so that the trust can't accumulate anymore after you and your grandchildren have passed on. It has to be, it can be passed on significantly beyond your grandchildren because they may have children and grandchildren. So they keep renewing the trust asset. Let's say it's a very potent, you have a good asset base worth significant amounts of money. Then you can make sure that at least it goes that far in its purpose or time, but they can't accumulate anymore. And if nothing is done, then the trustees would take all the assets and pay out according to the ratio that you have as a beneficiary. So it's all handled down the road. It can be renewed, but it has to be actively renewed. And then as long as that trust is able to keep on working, and beneficiaries say, okay, we'd rather keep the investment or the asset portfolio that's in the trust, and all we want to do is we want to have a payout. Now what happens is sometimes, let's say you have grandchildren, and before you pass on, then they have children. So all of a sudden there's a whole new level of beneficiaries that can take advantage, and either they have to either renew the trust or disband the trust, and then it's whatever's in the assets goes out to each beneficiary. So we have must be lawful. You have the rule against perpetuities. In other words, you're going to learn how to keep it going, how to have the trustees create new trustees if you want. You can give a list of people that you want to have come in and be part of the trust or be a trustee in the future. You can make that list of, and goes into the trust document form. I suggest that you get a ring binder and keep everything separated and easily accessible. So I have the trust indenture, which is about 13 or 14 pages. And it's very clear and decisive on what is going to go on within the trust. And then the accumulations will either stop or go on, because if you decide that you want to keep this trust going, it's got a really substantial asset base and you want it to spread out, you can do that. But what happens sometimes is, let's say it's 2 or 3 generations, then you can let it go and it can be sent out. Let's say what happens is there's too little asset, there's too many beneficiaries down the road, then you would want to either give it to all the beneficiaries and then they can set up their own trust and they use that and they invest. Either they do or they have the trustee put it into an investment process portfolio and it continues to grow. And in the meantime, let's say it's gone from 10 beneficiaries and you divide it up 10 ways, and then each one of those 10 beneficiaries can choose to either take that asset or to create a trust themselves and keep it going that way. But it breaks the asset base down a little bit, but at least some people want to have their share now and do their own investing or work the asset portfolio the way they would like. So those are the 2 things, and if you got questions, write them down and we'll deal with those questions in a little bit. Okay, next slide. Okay, so this kind of sums up what I'm going to talk about today, but we'll expand on it. So you've created the creation of express trust. That means that you have decided to create a trust. And what that becomes when you're alive and well and taking care of your asset portfolio or whatever you have, then you basically, what they call is an inter vivos trust, which is it's created while you're alive. It's not created from a will, which is a constructive trust. But this express trust is by your, you want to make this happen and get it out of your hands and keep it protected and also continue growing. Okay, a requirement is a declaration is when you declare that you want to set up a trust. And that's what happens when you go to Brilliance and Commerce, that's basically your beginning date for the trust. You say, I want to create a trust. There's your declaration right there. And when you get the trust document, you will sign, part of that would be the trust indenture, which is about 13 pages. And that's your requirement to declare that you're setting and working a trust. Then you need to make that delivery to the trustee. So if you have a particular asset that you want to go in, then you write a note, say, trustees, I want to have this asset go into the trust and I want to take an active role in working these assets, either through wealth manager or through a lot of these banks have funding process or trading commodities or anything like that. So you have to deliver it to the trustee, and accordingly, he's trustees must sign the acceptance of these assets into the trust. And how you do that is there's schedules, A, B, C, and addendums. Okay, so Schedule A is for personal property. We talked about that. Your jewelry, say you have a $10,000 sound system that you want to be held in trust, or a fancy car. Although I hesitate to say that I would not. I would have all of you never think about putting a liability in with your assets. And a car or a boat or an airplane are both liabilities. So you want to separate all of those personal property items that you want to keep separate from yourself into Schedule A. And Schedule B, that's assignment of property. You might have a piece of property right now, I'm working with a couple of clients as we speak, that want to have their property go into the trust, and the trust would hold the property. And then that's assigned to that Schedule B, and then you and at least one trustee would need to go to the county and have the transfer of deed to go from your name to the name of the trust. And Schedule C is a list of the beneficiaries and the percentage that is going to go to each one. When we set it up, like I had a client this morning that hadn't put any percentage of who he wants. He had a number of beneficiaries, but he hadn't put the percentage that he wants to go from the trust to them. So that that's where Schedule C would come. And that list, the Schedule C is important because they want to see, somebody may want to see the fact that there are beneficiaries who would receive some of the asset base on a percentage-wise, or could be a fixed number. So Schedule C might say, Cousin Ralph, I want the trust to give him $10,000. And then he would be, once he has that, then he would step aside. He would have gotten his part of the trust that he was given by Uncle Joe, who signs. And then while we have an addendum specifically for the foreign currency that some of you are holding, and you want that addendum, that's the one page that needs to be notarized. You can notarize, what happens is there's a trust indenture, and then there's assignments and appointments, and then there's the beneficiary base, and then that's like there's an abstract that comes at the end of the trust. In other words, after A and B are filled in, then addendums would take place. Let's say you hold foreign currency and you assign it to this addendum, and that's what you have to notarize. But that all of the documents have to be signed by the trustees, you and or the trustees. And you can, I've had clients, I had it for a while where you would take the abstract and you would sign it in front of a notary, all of it. But I went back to my original teaching, and we never used to have to go to a notary except for transfer of land on Schedule B. But you will need to go to a notary for addendum Schedule A, which is foreign currency. Now, some of you have been opening up the bank accounts already, and I advise all my clients to do that they need to take that addendum for the RV foreign currency and take that out of there and not talk about foreign currency to anybody, or especially to a banker, until the RV happens. And then when the RV happens, then there'll be a whole nother process for that to go. So that's who signs. You as grantor, you as general manager, and the trustees would all sign wherever their names are. When you get the trust document, when I've gotten the form for you and it's done correctly, then I'm going to send you all of those three or four parts, and you can separate it out, make one each separate, and especially addendum Schedule A, you want to take that aside until the RV happens, and the minutes are private, and so you can take those out too, or you can leave it in the way it's the numbers that are on the pages. If you take out certain parts of it, they may say, well, where's this part? And you just have to say that those are amendments and addendums, and I don't need to show that to you at this time. So the minutes are private, and your amendment for foreign currency is private, and they don't need to do that. And sometimes I had one client that went into the notary, and she wanted to see she wanted herself to notarize the whole document. And I said, no, that's not the role of the notary, is not to okay the document. The role of the notary is to notarize your signature, and you really only need it on addendum A, which is for foreign currency, and you don't need it on the rest. Or if you choose, you can, and your trustee is with you, or you have the two trustees, you can go to a notary and take the abstract, because part of the trust document will be an abstract, which is a condensed version of the whole trust document down to 1.5 pages. And then trust certification is where the trustees verify that this is what it is and what's in here. And it can all be notarized if you choose, but it don't have to be. The only thing that needs to be notarized is the foreign currency. And I caution you to talk about any foreign currency until the RV happens, and certainly not to the banker. That will cause a hornet's nest to happen. So leave that aside until the RV happens. And don't worry, you'll have plenty of time to collect that asset base from the addendum of what you put in when the RV happens. And of course, everybody's signing where their name is. There's grantor, there's assignments and appointments, and there's the beneficiary document, and then there's addendums. And you may, over time, make amendments to certain aspects of the trust, which can be modified. The initial indenture really needs to stay as it is, and you really can't change that other than make minor little versions of it where the intent of whoever created the trust is not corrupted. In other words, you don't want to take the intent away from what it is. You can make minor adjustments. You might make a new amendment. You and the trustees get together and say, well, we want to do this aspect and we want to do that. Can we do that? And I say, yeah, you can do that as long as you make an amendment or a minute. Like in any good business, you make an amendment and you have everybody sign, and then you add it to the trust document. And if there are amendments and it's relating to your asset base, whoever's holding that asset base, if you've got it invested or whatever you've done with it, then you want to notify those people. Like if you have a trust checking account now and you make an amendment, you want to make sure that if it's necessary, that bank or that investment portfolio understands that you have made an amendment to the trust. And everybody signs where they sign. It becomes all set up where you sign as an individual. The first signature is the grantor signature, and you sign that as a person. You personally sign that you have created this trust. Or whoever, you might have a nominee grantor, and they would have to certify that they have seen this document and I'm signing. But the documents a lot of these documents are private. The minutes are private, and addendum A for your foreign currency is private. Bankers already had a client that took her RV foreign currency page to the bank, and the banker basically lost it and couldn't deal with it. So don't be talking about foreign currency, especially before it happens to the banker. It's really none of their business anyway. So is there another slide? I don't think so. Yeah, so we've covered that, and let's open it up to questions.
Okay, everybody. Yeah. So those who are listening by telephone, press *9 if you have a question. That'll raise your hand. And those who are watching by video, on any device that displays video, you have a raise hand icon at the bottom if you want to speak, or otherwise you can type your question into chat. We have Dominique Randall. You recall her in California.
Well, I'm sure once I saw her whole name, Dick.
Okay, so in California, she says notaries are to ask for the whole document in order to glance and see that there are no unfilled blank lines. We can only notarize a filled out document. This is California notary laws, might be different in other states. This is why we look at the whole document. We do not care about the contents, only that there are no blank lines. And yes, I am a California notary.
Well, I don't know the specific laws, but when I go to my notary person, this is in Hawaii, so I don't know what it's like in California. I left California a long time ago, and in the early days in the 80s when I was with my mentor and we were writing a lot of trust documents, it wasn't even necessary to notarize anything. But if they want to see, well, you only have to notarize, that addendum A. Once that's done, now some notaries may want to see that filled in. So in the beginning, first of all, you say, look, I just want you to witness my signature, notarize my signature. You can do it that way, and you can, let's say you have 100 dinars. You can just, you can put down 1 dinar, and there's something in that Schedule A, Addendum A, and you can do it that way. When I go to my notary and I handed her a blank Addendum A, and she said, do you know what this is for? And I said, yes. And she knows that I do trust documents for people, and she said, okay. And she notarized my signature. That was it. That was all that needed to be done. And my partner, Marissa, she went along and she signed her name, and it was notarized. California, I don't know. I've done blanks, and I haven't had recently, I haven't had any problem getting a notary to sign whether it was blank or whether it was filled in. Now, you can also take that Addendum A to the notary, and you can fill it in. You can say I have 100 dings and 100 dongs and 100 other things, and then put a piece of paper over it, say, I just want you to know that there's a document here, and I just need to have you notarize my signature. And if the notary is worth any salt, then she'll say, fine, no problem, just give me some ID and I'll notarize this particular document. That's the only one you need to notarize. But on the other hand, you want to make sure that all those signature spaces are filled in. Okay, question?
So Dominique, I would say if you wish to share anything more verbally, please raise your hand and we'll put you on the air. Meanwhile, I'll go ahead to Joyce in Bahamas, who is being unmuted. Joyce, if you would like to say hi, you're on the air.
Hello.
Hi.
Bahamas.
Hi, Joyce.
Hi there. Really
Yeah.
today. So I I think I just typed it in. I've had a day full of things, and one of them was my wealth manager from Chase just dropped me. He said, I think you better look for another bank. Because I asked him if if they had a de la rue machine. And I just heard you say, Randall, that you don't tell them that you have currencies. But
not at this time, I wouldn't.
no, well, he knows. He knew.
Yeah.
And he says, I can check and email you about the dong, but if it's a Iraqi dinar, we're not dealing with that. So you have to go look for another bank. So my question is there any kind of bank? I mean, I'm in the Bahamas. I could use a Bahamian bank, but everything is set up with the trust for it to be in the United States. So,
well, you'd have to start going back. Whenever you go back to the U.S. or how you connect with your trustees is you just have to go look for another wealth manager, another trading account, or however you want to work that asset.
but
I don't. I had good luck with a Bahamian bank. It was when we first went there. It was 92 or 93. I'm sure things have changed, except for conch salad, right?
they're all still good. All still good. So yeah, because Barclays, I used to deal with Barclays, but I deal with Scotia Bank now.
Okay.
And trying to think of another one. I can deal with Scotia. I'm sure my brother would know the manager there, but I'm thinking for myself, if I were to go to Florida again, what I am going, do I go to another wealth manager in another Chase bank because I only have Chase there?
Well, you can either do that, or let's say you have you're banking with Scotia Bank. You're carrying. Let's say if you take the trust to them, you have a personal relationship with them already, and you ask them to open up a checking account for your trust. And then if they say yes, then you're going to get a debit card or a credit card and a checkbook. And that is going to go with you. Everything is online now, so you can bank anywhere and it's all done electronically. So I don't know. I had good luck with the banks in Bahamas and all through the Caribbean when I was spending some time there. We had a private account. Tons and I both did a big seminar in Grenada, and it was fine. It worked out really well, and it was mostly private banking. It worked. So either Scotia or when you go back to Florida or up to Massachusetts, just walk into the bank with your trust document and say, I have a trust I have an account in the Bahamas, and I'd like to for this trust, and I'd like to have one with your bank. And you just walk in and talk to the manager and say, hey, here I am. Let's open this account. I want to operate a significant cash flow through you. Then you can have two accounts. I have 3 or 4 accounts I have 2 banks on the mainland, and I have 2 banks here on Kauai. I don't have my Bahamian or my Grenada banking anymore.
Oh, okay. So I can actually go just right here to Scotia and the other banks that I deal with here.
Sure.
And with one of them and open an account just for the trust.
Yeah.
And with that same one, I can actually, when I go to Florida or wherever it is that I'm going, like you say, to Boston, I could also talk to them and say, okay, I have this account, and I'd like to also deal with you.
Yeah.
Okay. So, but it doesn't really matter whether it's Chase.
No.
Okay.
No. I mean, I have two bank accounts for my business or my trust that I have, and I have other trusts, but I have two accounts for one trust in two different banks, and I have other accounts for other trusts that I control, and we have bank accounts here and the mainland. And you can go anywhere in the world. You can go over to Europe, or you can go to different islands in the Bahamas, or you can do it in the U.S. or wherever you feel comfortable operating an account. You could go up to, if you go up to Boston, you got to go to a Boston Bruins hockey game, and then you could go walk into a really significant bank in Boston.
Okay.
You got to go to the Garden and have a hot dog with your hockey.
Oh. No, I think I prefer to have the lobster.
Okay, lobster, for sure.
The lobster.
Famous.
Oh, well, thank you. Okay, good. So I don't
You're
have
welcome,
to worry about the wealth manager. Okay, perfect.
Thank you, Joyce.
Thank you, Tansen and Randall.
Yes, you're welcome.
Thank you.
Marianne, we have you asking a question. You're on the air.
Hi, Tansen and Randall. This is Marianne from Quebec. How are
Hi.
you guys?
Oh, another hoser.
Here I am. As you know, Randall, my trust is complete. It's notarized. Now I'm questioning myself about adding maybe a trustee after the RV arrives. So is that possible?
Sure. Now,
And
you have two trustees now. Is that correct?
I have a trustee and a successor trustee.
Okay. So you can add a trustee anytime you like. You can move the successor trustee up to be a co-trustee, or you can find somebody, maybe you have a new trusted friend that you want to have them be a trustee with you. And that can happen.
My understanding is that it also could be related, because my actual trustee now is non-related. So I could have one that's related.
Sure, absolutely.
Okay, that's good. And do I have to go back to the notary to officialize this new trustee?
No. Again, the only signature that needs to be notarized is on the Schedule Addendum A for your foreign currency.
So that's all done. It just the new trustee would just go into the minutes and all the tracking of everything.
Sure. If you go through the trust document, you'll find an appointment for the trustee now, and you can make a copy of that, and then you can change the name that's you're appointing to whoever you want to appoint now, and then the other trustee signs and you're done. You don't have to get that notarized. You can, but you don't have to.
Okay, well, that's great. Could it be done the other way with like two signatures? Like sometime we said something like that it could be two people, like witnesses signing a document?
Yeah. Sure, I've done that. I have
for the second trustee would be okay.
Say again, please.
So that would be enough for a second trustee to have
absolutely
two witnesses. Okay.
Well, you don't even need that. You can do that if you want, but you really just need to appoint the trustee you have at present time and yourself. You would say, we want ABC to be our third trustee or co-trustee, and then both trustees now would sign it. Or if you're the only trustee and you have a successor, then you would sign it and they would accept that appointment, and it would be going from there. And you put that acceptance sheet in the trust document and keep it private and keep it safe.
Okay. Perfect. I have a really weird detail here because I've read some things about when people sign, they need to use a blue pen or forget if it was blue or black. And lately I had my trustee sign the document for the bank because we hesitated in between, you know, signing it before we go to the bank or in front of the banker. So I, just in case, I had her sign it, and she signed with a pink pen.
Yeah, that's
anyway.
fine. Yeah.
It's okay.
Oh, yeah.
It's
No.
a weird question, but I was really.
I have a document right here.
Okay, so it is
I have
okay.
a document here that basically I signed it as trustee and put my thumbprint on it in red ink over my blue ink pen.
Oh.
So we can do that. It doesn't matter what color it is. I mean, if you go to a banker or a notary, they just use black. So
yeah.
I guess when we were doing the International People's Public Trust, we did everything in blue ink and thumbprinted everything. So I got in the habit of just, if it was an important document, I signed it in blue and thumbprinted it.
Okay.
Yeah.
Well, that sounds great. Thank you so much for answering my questions. And thank you for all the information. It was great.
Okay, I'm going to show this to you. And can you see that?
Yes, I do.
That's all you need.
Well, that's perfect.
As long as you have your thumbs.
As long as I have thumbs, I'm okay. Okay, take care. Thanks a lot.
Okay, thank you.
Thank you, Marianne. Okay, we have questions in chat, and this one says, Trustee 1 is in Florida, Trustee 2 is in Georgia. Some strategies to notarize the Schedule A?
All right, so here you have multiple options. You can take the original and your trustee in one place signs it, and then wherever he's supposed to sign, he or she, and then he sends it back to you, or he can send it on to the other trustee who is somewhere else, and then they would go and sign the whole original. Or you can take the original, sign it yourself, make copies of it, a number of copies of it, and then send one copy to one trustee and one copy to another trustee, because ultimately you want to make copies of your trust, and you want to have the trustees have a current copy anyway of all your work. And every time you do a significant decision or you change anything, then you want to make that copy available to each trustee.
Okay. Any other questions, anyone? We can close early today if you like, or if there are other questions, you can go ahead and raise your hand or type it into chat.
I see a hand.
All right. 801 area code, you are on the air.
Thank you. You were talking about liabilities. Do you put your liabilities into a separate trust?
If you want, like people say, well, I want to put my car in trust, and I would say, don't do that. If your car has any value to it, then put it in a separate trust. But you don't really need to take a car, an ordinary car, and put it in trust. You have insurance on it. If you own it, you own it. What you want to do is take your assets and put those in trust, and then take your liabilities, potential liabilities, and keep them separate, either in their own trust or, outside of the trust. And that also leads me into if you have a piece of property, the trust owns a piece of property, you need to make sure that you and the trustees take care of that. There's insurance on the house, that the house or the unit is well kept and any repairs are made, because you don't want that house, if you're not living in it, to be a liability. So I would encourage you to put any land into the trust if you want to keep it separate from yourself. So on the personal level, say you're involved with some litigation or the potential of litigation, then I would have you separate your assets sooner than later.
Got it. And then on multiple properties, like commercial properties and multiple vehicles, multiple types of, say, airplanes or boats, any of those type things, those would all be in a separate trust as well.
Randall? Well, ladies and gentlemen, it looks like we lost Randall. We'll wait for him to come back in. In the meantime, yes, the general principle in asset protection is one trust for every different significant asset, different vehicles, different properties. It was said back in the early 90s that the Rockefellers had some 7,000 of these trusts. So yes, any different separate asset, large bank accounts you could separate by whatever demarcation you feel suits you, whatever levels of cash or stocks or other monies, make sense. To never put all your eggs in one basket, that's the principle.
Okay, that's clear. So then multiple properties you would separate into individual trusts, because I'm going to be holding millions of pieces of property all over the world. And so each trust would be would it be domiciled in that separate area of the world?
The item itself doesn't necessarily need a domicile. It can be located anywhere, and its location can be identified in the trust. And yes, I suppose you could say if there was an incident that were to occur related to that item, that incident could be under the common law of that area of the world, not the trust itself, but just the asset.
Got it. Thank you very much, Jonathan. This is Robert Sakahara. Thank you.
Hi, Robert. Yes, very good. We had a question earlier while we're waiting for Randall to come back on that was asking about the 1041 form. That's for those of you from other countries. In the United States, the form that statutory trusts use to file tax returns. No, it is not required for the natural law trust to file that form because the natural law trust is not statutory. Then we have a question. Is it okay to ask about a question from the last seminar, putting an LLC into the trust, or is it better to close a statutory LLC? That varies from person to person, Dominique, and from case to case, from situation to situation. There's no one answer to that. It can vary depending upon your circumstances. It can vary depending upon whether the bank that you have the account open for with the LLC has had that account for years and years and years, and you've had an accountant managing it, and it's comfortable and everybody understands it. What you can do then is just put majority of the ownership of the assets of the LLC into the trust. Put up to 98% or so. You don't want to put 100% because you don't want to raise too many eyebrows. But yeah, you want to, basically do what is customary and comfortable. I myself don't have any need for them. If you find that the LLC is no longer as necessary and you want to operate directly from the trust, you can do that. All right, ladies and gentlemen, I think we have Randall back in. Let me put him on. Hold on. Well, we have Randall connected, but I don't think we've made him visible yet. So while we're waiting for that, Randall, if you're hearing, turn on your video, turn on your audio. You've been made co-host. Now, Robert, I believe I still have you on the line. 801?
Yes, I'm here.
And did you have more you wanted to say?
On LLCs, you keep them separate and you do not put those into a trust. Is that correct?
No, you can put the assets of the LLC, the income and the assets, like up to 90, 95%, maybe 98%, so that it owes very little tax on that, and the trust owns the majority. That's how people who continue their LLCs do it.
Okay, and then you would assign your assets and any sort of cash into the trust. Is that correct?
Right.
Got it. Thank you. Thank you very much.
Yes.
What about an age limit? Is there an age limit to someone that can be a trustee?
It has to be legal age, age of majority, the kind of age that would be acceptable by a bank.
Got it. Thank you.
18 or 21, yeah. I'm still trying to bring Randall back on. Okay, well, Mr. Jay, we have you with your hand raised. Hold on. You are unmuted now.
Okay, thank you. Yes, this is Joby, and I have a question.
Can you speak just a little louder, please?
Yes, this is Joby, and I wanted to ask, I have 2 trusts, and with the foreign currencies, can I break those down and put them into 2 trusts, and once the RV take place, go to the bank with different trusts? Or does it all have to be in one trust?
It depends on your wishes. It depends on your priorities. If you have a use and a purpose for 2 different separate trusts, keep them separate.
Okay.
So each trust has its own purpose. Some are holdings, some are religious, some are humanitarian projects, some are family.
Right.
Absolutely.
Absolutely. I was just listening to some of the gurus, and they had indicated that you can only have it in one entity when come time to RV.
Well, you want to exchange into one trust, yes. And then you can distribute the proceeds thereafter into as many trusts or entities as you wish.
Okay. Okay, well, thank you very much.
You're welcome. Randall, we have made you co-host. We've given you the invitation to turn on your video and audio, and we still don't see you. So sorry. I don't know what's happening, but sorry to miss you. I don't know if it was weather or what happened in Kauai. We've had record snowfalls here in the Washington State area. And Hawaii, we heard about high winds and high waves in Maui. Okay. Peter says, I have a statutory entity that has a promissory note of very significant value. This promissory note may be sold or a service may be delivered to meet requirements to have the issuer make a payment in cash. I am considering selling the promissory note to a trust or the trust purchasing about 98% of the statutory entity so that the value of the note can come into the trust. Does this look advisable, or is there a simpler, more preferable way? Well, and I'm still waiting to see if we can get a sound for for Randall, but yes, you can transfer any asset of any value by changing the title of ownership to the trust and any percentage thereof, 100% or 98%, whatever you wish. And when you say selling it, yes, you can sell it. You can exchange it. We use the word exchange or assign to the trust. And the trust, what would it give in their exchange? It would give units of beneficial interest. So the trust would give units of beneficial interest. The amount of the units of beneficial interest would be determinable on a individual basis, depending on how you evaluate it, but at least the units are not publicly traded and they're not of any publicly determinable monetary value, so they cannot be taxed. And that goes for any kind of asset that could be transferred to the trust. Ladies and gentlemen, really appreciate you joining us at Brilliance and Commerce for February 13th. I've been unable to bring Randall back on, and I guess we're mostly complete. It appears we've answered all or most of the questions. Wanted to really thank you generously for being with us today, and join us March 13th for the next one. In the meantime, keep in touch via our newsletters, and of course, if you have private communication with us, you're more than welcome. And the past webinars are visible at brilliance-videos.com. For those who don't have any contact with us at all, the website is house-of-freedom-trust.com. And then, of course, we also have our phone number, 360-200-7521. And if you have not already subscribed to the newsletter, go to that address, that house-of-freedom-trust.com, and click on newsletter sign up. So aloha, thank you, namaste, blessings of abundance, happiness, and joy to everyone, and may you have a beautiful, beautiful day.